Good afternoon. It is our distinct pleasure to welcome Professor Siobhán Mullally, who is the established professor of human rights law and the director of the Irish Centre for Human Rights. I have had the recent pleasure, quite recent, of meeting Professor Mullally in Washington, D.C., not just during the American Society of International Law, but also at our own Notre Dame Cloud Center for Civil and Human Rights Roundtable on Human Rights Fact-Finding, where she gave us excellent session of her own work at the Center called Contested Human Rights Practice. Very interested in today's discussion because it is human trafficking, protection, and rights. You will find, as I was telling Professor Mullally, that there are many engaged students at the Keough School on this complex question on trafficking, particularly deep intersections with migration and regulations. Professor Mullally is a commissioner of the Irish Human Rights and Equality Commission, a member of the Permanent Court of Arbitration at the Hague. He's also very well known as the editor-in-chief of the Irish Yearbook of International Law, a well-respected global expert on gender, women's rights, migration, refugee law, and policy. He has worked extensively at the United Nations as an advisor on human rights, migration, gender justice, as well as held visiting positions leading law schools, including Harvard, Columbia, Cornell, and I expect let me not take away from our time. Welcome.
Thank you.
Thank you.
Thank you. Thank you very much. I'm delighted to be here this afternoon. Thank you to colleagues in the Keough Institute and in the Cloud Centre for the opportunity to collaborate and to talk to you a little bit about my work on human trafficking. I'll be talking mostly about the work of the Council of Europe, in particular the treaty monitoring body on human trafficking, the group of experts on action against trafficking. I've been chairing that for the last 2 years and was a member of the treaty monitoring body for 4 years before that. So I'll be drawing on that work, but also highlighting some of the more contemporary debates at a global level in terms of defining human trafficking and strategies to respond to human trafficking. And I'll leave as much time as possible for Q&A and discussion. I'd like to hear your comments, your thoughts also, and to respond to your areas of interest. So many of you may be familiar with the Global Compact on Migration, which was adopted in December 2018 in Marrakesh, marking Human Rights Day and also 70 years of the Universal Declaration on Human Rights. It's what we call a soft law instrument. It's not a binding legal treaty, but it nonetheless was quite an important normative statement in terms of a global instrument looking at a whole range of questions relating to international migration. Until then, international standard setting on migration had tended to be compartmentalized to look at questions around refugee protection, human trafficking, migrant workers and their families, but we didn't have one comprehensive legal instrument looking at migration. And Objective 10 of the Global Compact focuses in particular on human trafficking and sets out the objectives for states to strengthen prosecution of trafficking, but avoid criminalization of migrants who are victims of trafficking, ensure that victims receive appropriate protection and assistance, including access to specialized measures, physical, psychological, and social recovery. And I highlight those two parts from Objective 10 because all of the preceding paragraphs in Objective 10, that's where you get to paragraphs G and H, if you can see on the slides, but all of the preceding paragraphs under Objective 10 focus on the criminal justice response, effective prosecutions, investigations, international cooperation. And despite the fact that we've had almost 2 decades of what, at least in theory, is supposed to be a human rights-based approach in responding to human trafficking, the primary international focus continues to be on criminal justice responses, combating impunity, of course, for human trafficking networks and for individuals involved, but also, unfortunately, the expansion of criminalization has meant, to some extent, an overextension of the criminal law to include criminalization of migrants more broadly, and increasing criminalization of smuggling. And we see that throughout the drafting process of the Global Compact over the last 2 years, and it really began with the adoption of the New York Declaration in September 2017. And that process was co-chaired by Ireland. Ireland and Jordan co-chaired the adoption of the New York Declaration. And then since then, the process leading up to the adoption of the Global Compact on migration was co-chaired by Mexico and Switzerland. But throughout that process, it was quite a battle to try to retain the human rights-based approach and to include language that would strengthen the rights of victims of trafficking and avoid expansion of criminalization. I'll come back to that, but you can look at this yourselves. I'll make these slides available, so I am going to go through them pretty quickly just to cover some ground. But despite the fact that it's not a binding legal instrument, it was still hotly debated, and we were discussing this with students earlier. 5 countries voted against the Global Compact, including the US, and 12 abstained. And of those voting against, we also had a number of EU states, Bulgaria, Romania, and Poland, all of whom are party to the Council of Europe Anti-Trafficking Convention, and that I was chair of the monitoring group, so that was quite problematic for us. And this is, as I said, despite the fact that it's not a legally binding instrument. So we see the extent to which the whole debate around migration, human rights of migrants, became highly politicized and caught up in other political dynamics at the UN and multilateral initiatives. Just to mention a few other current developments with regard to human trafficking, the Sustainable Development Goals. Several of the Sustainable Development Goals have particular targets relating to human trafficking, including in relation to women and girls in both public and private spheres, sex trafficking, and other types of exploitation. Target 8.7, that has led to a whole global alliance and civil society activism around this, relates in particular to forced labor, including child labor in all its forms, and includes recruitment and use of child soldiers. So it broadens out there to include a wide range of forms of exploitation. Other targets relate more specifically to children, and also just to note, Security Council Resolution 1325 on women, peace and security that was adopted in 2000. Next year will mark 20 years of the 1325 agenda, and the whole question of trafficking of women and girls and the nexus between trafficking and conflict situations has been highlighted in particular through the work of the UN Special Rapporteur on Trafficking. The UN High Commissioner for Refugees is also currently looking at questions around access to international protection for victims of trafficking. That is partly because our current legal standards don't impose obligations on states to grant residence rights to victims of trafficking. So although you may be identified and recognized as a victim of trafficking, it's still left very much to the discretion of individual states to decide whether or not to give you any kind of residence permission, even for a short term. In the EU context, it's conditional on cooperation in a criminal justice investigation. But if you're too afraid or not ready to do that, or don't want to do that because of fear of reprisals for your family, for example, there's no obligation on states to grant even a short-term residence permit. So access to international protection, to asylum, to refugee status is what is referred to as a more durable solution. But the guidelines from the UNHCR on looking at trafficking and international protection go back to 2006. So they're quite out of date, but they're currently being looked at. And the other point around the 2006 guidelines is that they are very much focused on women and girls and very much focused on sexual exploitation. That was the main way in which trafficking was understood at the time. So there's very little, there's a brief reference to other forms of exploitation and a brief reference to men and boys as also being possibly victims of sexual exploitation. But it wasn't recognized much at the time in the drafting process. And it's something that will now, I think, be included in a revised draft. The whole international law on human trafficking goes back, although the Palermo Protocol, the main legal instrument from 2000, is relatively recent in terms of developments in international law. There are older historical instruments that referred to the so-called white slave traffic, to obligations to suppress traffic in women and children, and traffic in women of full age. This was very much concerned with prostitution, sexual exploitation, and a very limited focus in a European context in particular. So it wasn't until 2000 that we got a comprehensive legal instrument on human trafficking, the Palermo Protocol. And it's a protocol, an additional legal instrument to the UN Convention on Transnational Organized Crime. So it was in that framework of addressing transnational organized crime that human trafficking was looked at. And that was the first time that we got an international legal definition of human trafficking, and it reflects that particular positioning. The legal definition of trafficking from the Palermo Protocol is about transnational movement of persons across borders. More recently, in the Council of Europe context, we're addressing internal trafficking within states, but at an international level from 2000, it was transnational. We also now have the ASEAN Conventions, Association of Southeast Asian Nations, which just entered into force in 2017. And that is the Convention Against Trafficking in Persons, with a particular focus on women and children, but not confined in terms of its scope. So quite a few developments happening. At a European level, which is where I've been working in more recent years, and the International Labour Organization, we have a number of recent developments. EU level, you have the Council Directive from 2004 and more recently 2011. Those are important developments, but again, I would emphasize that they are conditional in terms of the protections given to victims of trafficking. Cooperation with the criminal justice system is essential. We also, however, have from 2005, the Council of Europe Convention. Council of Europe, as you may know, comprises 47 member states, so much larger than the European Union. And all of the Council of Europe member states are parties to the Anti-Trafficking Convention, with the exception of Russia. Russia has not ratified the convention, and that is quite a problem. So 46 member states of the Council of Europe plus Belarus. Belarus has observer status in the Council of Europe. So they've all ratified the convention. It is open to ratification by other states, and a number of countries are looking at ratification outside of the Council of Europe. What's important about the Council of Europe Convention is that it imposes much stricter obligations on states to provide protection to victims. Assistance, specialized shelter, short-term residence permits, again, 6 months, but also a recovery and reflection period of a minimum of 30 days, during which a victim of trafficking cannot be returned to their country of origin. And any returns should be safe and preferably voluntary. Forced returns are not prohibited unless there's a risk of persecution on return. But again, there is a push towards trying to ensure some kind of residence as a remedy to the crime of human trafficking. The defining, some of you may be familiar with the definition, but just to note briefly, trafficking in human beings, that's the acronym THB. The crime itself requires an act, recruitment, transportation, transfer, the means, coercion, fraud, deception. For example, recruitment agencies working, offering jobs, perhaps allegedly in restaurants or hotel, but then a person being forced into prostitution, or use of force, abuse of a position of power or vulnerability. There's a whole set of issue papers on that, but that's quite important, for example, with regard to people with intellectual disabilities, who may be in a position of vulnerability, people who are undocumented or in an irregular migrant situation. Again, there can be an abuse of a position of vulnerability as a means to facilitate human trafficking. And the purpose is exploitation. Exploitation itself is not defined, but again, there's quite a bit of practice on this. but it can include sexual exploitation, forced labor, domestic servitude in a domestic work context, removal of organs, and other types of exploitation. And there's a debate about whether it can include forced marriage, for example, and forced begging or exploitation of begging in the context of child refugees or child migrants. That's a current concern in a number of regions. So it's quite broad in terms of the range of types of exploitation, but the main international focus until recently has been on sexual exploitation. So trafficking and smuggling, just to note the distinction, smuggling is where there is an element of consent. A person may be paying someone to help them get across a border irregularly or using fraudulent documents, but there is an element of consent or voluntariness about it. Whereas trafficking, it's about deception, coercion, use of force, a lack of consent. Of course, there are overlaps, and we might question to what extent any form of movement in a difficult situation where there are limited access to safe and regular migration, there may, in many instances, be a lack of consent. But increasingly, we also see smuggling being criminalized, of course, and even facilitation of humanitarian assistance that might involve irregular border crossings also being criminalized. But the distinction is the question of consent. And just to note with regard to children, of course, there can be no question of consent. So a child defined as under the age of 18, there cannot be a debate as to whether she or he consented to the particular act in question. And it's not necessary to show the means, fraud or coercion. It's enough to show the particular act, the recruitment or the transfer, and the act of exploitation, the purpose. Much of the debate at an international level and increasingly at a European level also has been around, and this goes back to a very early debate, the abolitionist movement, looking at particular at movements to try to abolish or eliminate prostitution. And this is linked in the trafficking context to be a question around, it's said to be a question around ending demand for sexual services, and therefore also ending demand for the services of victims of trafficking. This is looked at in the context of the commercial sex industry. So here we have a debate around what does international law require with regards to how prostitution is regulated and what is the nexus with human trafficking. At a European level, the European Parliament had quite a heated debate about this and looked at the Nordic model, which originally was the Swedish model, which criminalizes the purchase of sexual services since 1999. European Parliament has said that this is one way of combating trafficking of women and children, but not the only way. And the earlier drafts had referred to it as the most effective way. So that has been a source of some tension. The Global Commission on HIV and the Law has been quite critical of the push towards criminalization, has said that this is the institutionalization of an anti-prostitution perspective, and that it has led to an expansion of criminalization of prostitution and of sex work. Their argument is that this negates the right to self-determination, autonomy, and agency of sex workers. So it's a split position. UN Women, which is the agency for gender equality and women's empowerment at UN level, has a somewhat ambiguous position. It's not clear at the moment. They have a note from 2013, but a note is not a legal document. It's more it's not even as the stage of a policy position, I would say. But their note from 2013 called for decriminalization, so as to better safeguard the rights of those engaged in sex work. So their argument is that a harm reduction perspective is better served by decriminalization. On the other hand, at a domestic level, we have seen a number of countries going towards the model of criminalizing the purchase of sexual services from any person, so including from victims who are trafficked, which is already a requirement of international law. So in Ireland, for example, we adopted the Nordic model a year ago, Northern Ireland in 2015, and a number of other jurisdictions earlier. And currently, it's the subject of quite a lot of heated debate at UN level. The CEDAW Committee, which is the UN Committee on the Elimination of All Forms of Discrimination Against Women, is preparing to adopt a new general recommendation on trafficking for the first time. They're going through a period of discussion and consultation at the moment, but the general recommendation should be adopted next year, 2020. And I was talking to students earlier, we were looking at the various submissions that have been made on the draft general recommendation. You can look at those, they're all available online. You will see that they're highly polarized. So there are a number of submissions from sex workers organizations, others who are advocating and mobilizing for criminalization to eliminate prostitution as a way also to combating human trafficking. What is getting lost in much of that debate is the whole area of labor exploitation, domestic servitude, exploitation in agricultural work, and the broader areas in which trafficking can occur. But it's a very heated debate at the moment, and UN agencies are also engaging with it. The CEDAW Committee itself, in its own background paper on the general recommendation, has said that it's not looking at the regulation of prostitution, it's looking at trafficking. The problem with that, of course, is that many advocates, civil society activists, academics, Feminist International lawyer, Catherine McKinnon, for example, would argue that there isn't a distinction between prostitution and trafficking for the purpose of sexual exploitation. Her argument as a feminist scholar and as one of the drafters of the Swedish legislation in 1999 was that prostitution is inherently exploitative and harmful and constitutes violence against women and also trafficking for the purpose of sexual exploitation. So her argument is that it's not possible to consent. So it's not possible to make this legal distinction. So the CEDAW concept note is already in itself heading into terrain that is quite contested between legal scholars and feminist activists. So it will be very interesting for those of you who work in the field or are interested in the area. The regional discussions globally will be rolling out this year. So it will be quite a good time to follow that. The International Labour Organization has always taken a role around trying to strengthen the rights of sex workers. Amnesty International and Human Rights Watch, which would be two of the biggest non-governmental organizations at an international level, they also go down the road of decriminalization and strengthening the rights of sex workers. But we've seen other organizations, OSCE, for example, beginning to take quite a different approach. Just to look a little bit more depth then at some of the case law and initiatives happening at Council of Europe level. The European Convention on Human Rights, which is probably one of the most advanced regional human rights instruments in relation to the case law that has developed under it, has only recently begun to look at questions of human trafficking. The first case came from 2010. This concerned a young Russian woman who had traveled to Cyprus on a visa to work in the cabaret industry, was forced into prostitution and died falling from a balcony, having fallen from a balcony, trying to escape from her situation. She had earlier sought assistance from the Cypriot police, but had been returned to her employers, inverted commas. Now, the text of the European Convention on Human Rights, which is our regional human rights instrument, doesn't have any reference to human trafficking, but it does refer to forced labor, slavery, and servitude. And the court read that as including a prohibition on trafficking. Trafficking, they said, treats human beings as commodities to be bought and sold, put into forced labor, and was contrary to the values of the European Convention on Human Rights. Importantly, the Rantsov case and subsequent case law has said that there are positive obligations on states to take action, to identify and detect potential victims of trafficking, and to refer them for assistance and protection. Now, this is quite important in the current context of migration across the Mediterranean Sea, involvement of coast guards, the Italian and the Libyan coast guard in particular, but looking at Italy as a state party to the European Convention on Human Rights and a member of the Council of Europe, that they have a positive obligation to identify potential victims of trafficking and refer them for assistance, and also to ensure that they are not returned to a situation of human trafficking. So you don't have to wait for someone to say, I'm a victim of trafficking. The state has a positive obligation to identify potential victims. Also in the Ransom case, what was important was that they said there was a failure to conduct an effective investigation to cooperate with Russia. So the criminal investigation into Oksana Rantsev's death didn't meet the standards of an effective investigation. And that is something that's being looked at also in the context currently of crimes against migrants. Article 2 of the European Convention on Human Rights is the right to life, and it has these procedural obligations of effective investigation. So the Calais Centre's event in DC on Tuesday of last week included a keynote address from the UN Special Rapporteur on extrajudicial and arbitrary executions, Agne Calamar, and she has interpreted her mandate to also look at situations of deaths in the Mediterranean, crimes against migrants that are not being effectively investigated by states whose agents may be engaged, coast guards in particular. And that is also linked to positive obligations concerning identification of potential victims of human trafficking and their referral for assistance and protection. Just to note, also linked, and this comes from RANSEF, much of the international response to human trafficking has been about criminalization, but the court also said that we need to look at how our immigration rules are working. Are we facilitating human trafficking? For example, by tying migrant workers to individual employers, by putting migrant workers into situations where they can't change employers. That was something we looked at the Council of Europe level in relation to the UK, for example, where the domestic worker visa regime was reformed in 2012 to make it more short-term and to tie the domestic worker to an individual employer, what's referred to in the Middle East as the kafala system, a tied system of employment permits. But also that's what happens in many jurisdictions. And that was what was actually introduced in the UK into the domestic work sector in 2012, despite evidence and submissions from lawyers, NGOs, human rights advocates saying that tied visas or tied employment permits increase the risk of exploitation, including human trafficking. So I'm just going to mention briefly then the Council of Europe Convention on Action Against Trafficking. Hopefully I can show you this. This is the web page. You can have a look. All of the countries of the Council of Europe are involved in this monitoring process, and the group of experts, the monitoring body that I was chairing, has to visit these various countries, adopt reports. It's an incredible resource in terms of looking at human trafficking and responses on the ground, law, policy, and practice, and to get a sense of current trends in terms of data, statistics, forms of exploitation, and responses. So the link is there, and I'll leave it with you to look at. The treaty monitoring process has two pillars, so individual experts, a group of experts, and the Committee of States Parties, which is the political organ. And that's quite important because you have to get states to take the recommendations, to discuss them, and to try to ensure their implementation on the ground. The individual members of the treaty body serve in an independent capacity, so not representing any state or government, and they are not supposed to take instruction from any state or government. and also not represent any particular position, implement the convention. That can be problematic. You can have somebody elected to the 15-member group who doesn't like what the Council of Europe has said about their country in the most recent country report, or who takes a different position with regard to the regulation of prostitution, for example. So it can be problematic. How does the treaty monitoring process work? Through periodic country reports every 4 years, engagement with NGOs, meetings with government, and field visits. That's a convoluted map. Questionnaires to the state, meetings with NGOs, responses, country visit, recommendations, and a public report. The main gaps that we've found in monitoring Council of Europe member states, in fact, have related to child trafficking. Many of the states, at that time it was 40 states, 31 of the 40 that we had looked at did not meet their international legal obligations with regard to identifying child victims of trafficking, timely appointment of guardians, referring children into child protection, providing specialized accommodation, and ensuring effective remedies, state compensation for victims of trafficking. So the human rights-based approach really not being implemented. The recovery and reflection period, this is the period, minimum 30-day period, where if somebody is identified, they should not be returned to their country of origin under any circumstances. So what's happening at the borders, Bulgaria, Romania, Turkey, for example, if people are being returned immediately or held in immigration removal centers and sent back without a whole pre-removal risk assessment, without an identification process, then they're not being given a recovery and reflection period. There isn't any early identification process. Identification is critical to triggering the protection measures. The group of experts has also adopted a number of thematic reports, and partly this has been to try to broaden the debate and action at an international level, to look beyond sexual exploitation, to also look at other situations. The fifth general report we adopted in 2015 focused on the crisis of protection for refugees and asylum seekers in Europe, and looking at in the numbers of people who were being forcibly displaced from Syria in particular, but also through Libya into Europe, what were the risks in relation to human trafficking. And we were trying to highlight that it was open to states to manage migration, to issue family reunification visas, to expand resettlement options, and to allow people to travel safely from their country of origin. You can travel in the Mediterranean on a cheap ferry with a visa for €50, instead of having to pay 10,000 to smugglers, then getting into an irregular situation at risk of exploitation, including trafficking. Children could move through family reunification visas instead of their parents paying 5, 6, 7,000 and handing them over to criminal networks. So we were trying to highlight the risks of exploitation and the other kinds of options that were open to states. And also to point back to other historical periods, the Indochina refugee crisis in the 1970s, for example, when we saw the UK playing a leading role in bringing together states at a global level to expand humanitarian resettlement, family reunification, and provide rescue ships to rescue those, the so-called boat refugees, to bring them safely to countries of refuge, rather than forcing them into irregular situations and dangerous journeys. The sixth general report from 2016 focused in particular on children in the European context. This was a response to data from Europol, which is the European Police Agency, which suggested, and they continue, and European Police Agency, which is an agency of the EU, they're not given to sensationalism, but they estimated at least 10,000 unaccompanied and separated children missing, likely to have been trafficked in Europe. since the outbreak of the refugee crisis situation in 2015. We did a country report on Sweden, published in 2017, and there we documented 3,000 missing children between 2015 and 2017, just in the southern region of Malmo. And not one investigation had been opened into human trafficking in that region, despite very high numbers of children going missing, and concerns from social workers, from those working on the ground, that this was organized, the children were moving quickly and quite likely in exploitative situations. So we highlighted the need for proactive measures to identify children at risk, refer them to ordinary child protection mechanisms, timely appointment of guardians, and access to refugee status, and more effective respect of the obligation of non-refoulement, ensuring that children weren't returned. The Secretary General of the Council of Europe took quite an unprecedented step of writing to all heads of states of the Council of Europe member states to remind them of their legal obligations with regard to children on the move. The concern here being that children were being seen first and foremost as irregular migrants rather than children with a right to international protection. Our seventh, I'll come back to some of those points, but just to note, the seventh general report from 2017 focused on labour exploitation and highlighted increasing numbers of detected victims of trafficking for the purpose of labour exploitation in most Council of Europe member states, and a number of countries where the numbers of detected victims for labour exploitation was actually more now than for sexual exploitation. And we were really looking at sectors at risk: agriculture, catering, domestic work. And the report followed on from a number of important judgments of the European Court of Human Rights relating to the agricultural sector and the domestic work sector in particular. The eighth general report is due out within the next month or so, and it focuses on assistance to victims and the role of civil society and NGOs in particular. And this tries to highlight some of the current problems at a European level, but this is something that is happening globally. Increasing criminalization of the activities of NGOs, including a search and rescue at sea, and increasing regulation of NGOs, a particular concern in Hungary, which was one of the countries that we monitored, and in Italy, and difficulties for NGOs in securing funding, in operating freely and working to support migrants. So the UN Special Rapporteur on Human Rights Defenders, for example, has been trying to highlight the situation of advocates for migrant rights, and other academics and others have been highlighting the right to rescue, not just the duty to rescue, but in fact the right to rescue, which has been infringed, if not violated, particularly in the Mediterranean at the moment, but also in other contexts from the Pacific, for example. We visited Calais in France, the Calais camps, where the report from the Council of Europe was published in 2017, but highlighted the very dire situation for unaccompanied and separated migrant and asylum-seeking children in particular. At the time we visited, there were several hundred children as young as 9, 10, 11, without shelter, without guardianship, not having been referred into child protection systems. And the European Court of Human Rights, I'm very happy to say, handed down a unanimous judgment in February of this year, finding France to be in violation of the European Convention on Human Rights, Article 3, which is the prohibition on torture, inhuman and degrading treatment. They found, and this was a case that was brought on behalf of an 11-year-old Afghan boy who had been left without shelter for several months, not referred to any child protection system, and the court unanimously found France to have been in violation, to have subjected him to degrading treatment. He could in fact have been reunited legally with family members in the UK if he had been identified, referred to assistance, and enabled to travel. So a very strong judgment from the court. They cited the anti-trafficking report, but also the work of the National Commission on Human Rights of France and the Children's Ombudsman and UNICEF. And UNICEF UK and France had issued a very damning report in 2016 condemning the French authorities in relation to the treatment of children in the Calais camps. We also undertook an urgent procedure visit to Italy, to Sicily, to the hotspots. This is part of the monitoring process. The ordinary human rights monitoring, for those of you studying the field, as you know, it tends to be quite slow, periodic reports, monitoring. So to try to engage more effectively, we had adopted an urgent procedure process. So in response to, for Italy, it was just a letter from an MP. But we visited the hotspots, we visited an immigration detention center outside Rome and published a short, quick report highlighting in particular the treatment of unaccompanied minors in the hotspots and delays in appointment of guardians and the lack of child protection. A concern that was raised by IOM, the International Organization for Migration, and UNHCR was about the increasing numbers of young Nigerian women and girls coming through Libya in a much more increased brutalized state. So they were seeing heightened levels of violence, sexual violence in particular, and a number of young Nigerian girls arriving pregnant, which they were understanding as being a way of avoiding accelerated removal procedures, but then disappearing very quickly on arrival in Italy. So highly organized system coming through. We've just published a second round evaluation report on Italy, and the situation unfortunately had changed quite dramatically. You may be familiar with the Salvini decree, security decree adopted late 2018, the subject of a number of legal challenges, but that has meant the dismantling of reception centres in Italy and concerns around victims of trafficking who should have access to specialised shelters, now being caught up in a politics and anti-immigration politics and not having access to those specialised centres. It's also become increasingly difficult for civil society and NGOs to operate in Italy, in particular to engage in search, rescue and disembarkation. Hungary was another urgent procedure visit. We visited the borders, the transit zones, the camps where children over the age of 18 can be detained. That has been criticised by the European Court of Human Rights, but the judgment not implemented by Hungary. And victims of trafficking who are seeking asylum also come through the transit zones and are also detained in the camps, so subject to deprivation of liberty. So quite a challenging time at the moment. On the other hand, we've had, just to conclude, some important judgments from the European Court of Human Rights. The Chowdhury judgment in particular, a landmark judgment on trafficking for the purpose of labour exploitation. This concerned more than 20 Bangladeshi farm workers who had come to Greece with seasonal agricultural workers to work in strawberry picking. Their passports were taken from them. They didn't receive wages. They were physically brutalized. They were shot at one point when they had tried to leave. And their situation was brought to the European Court of Human Rights. They had failed in domestic legal proceedings, but the court found that Greece was in violation of Article 4 of the Convention, the prohibition on forced labour, servitude and trafficking for the purpose of labour exploitation. And they found it to be a situation of trafficking for the purpose of labour exploitation, even though they could, at least in theory, move around. But they said that they had been subject to coercion around their irregular status. In fact, they had also been shot at. But the fact that they had been seasonal workers, had previously consented to come and work, that didn't mean that they could not subsequently become victims of trafficking. So it was a very important judgment in terms of recognizing what the court said were subtle forms of coercion of seasonal agricultural workers and recognizing their situation of human trafficking and their right to an effective remedy. That case is now being used in the Irish context in relation to a situation in the fisheries industry and litigation being brought by the International Transport Federation on behalf of a number of men, victims of trafficking for the purpose of labour exploitation, they are alleging, in the fisheries industry in the Irish context. So it's potentially a hugely important case. Another case that's pending relates to Vietnamese boys trafficked into the UK for the purpose of cannabis cultivation and forced criminality. And UK lawyers have brought that to the European Court of Human Rights because the boys were not provided with protection and in fact were re-trafficked within the UK. So they're arguing this gap in protection in terms of their identification and referral for assistance. So that's a quick snapshot of some of the current work at Council of Europe level and current debates, and I'm open to questions, comments. I was just going to mention, and you might be interested, but you can follow it up, the International Criminal Court has opened a preliminary investigation in Libya linked to trafficking. Libya was already one of the situations under review following referral from the Security Council, but the prosecutor, Fatou Bensouda, has now expanded the scope of the situation being investigated in Libya to include potentially crimes of human trafficking, and that's the first time before the International Criminal Court, potentially. The Security Council has also, for the first time, issued sanctions against traffickers from Libya. 6 were issued just in summer 2018. So it's moving into a new domain there at UN level also.
Before we open the floor up to questions, I want to say thank you on behalf of the House Center, but also I wanted to ask the question in relation to the identification problem, which are recurrent happenings in the report. Now, one of the things that I was contemplating was what are the usual political, resource, or environmental reasons that states may have against having these identification problems? It seems to be a recurring pattern. The example I will give is that the European maritime security authorities that I had the opportunity to interact with when we were doing the ASEAN Maritime Security Cooperation Strategy with the European Union External Action Service. We tried to bring up the issues on rights, rescue, search, and disembarkation because there were analogs in South China Sea, particular migration, trafficking issues, and the Mediterranean. And the Maritime Security Authority said that really happens at a political level. Matter for the politicians. It's not for them to carry out within the framework of their maritime security strategy. But we said that's another subject matter delineation that fails to give effective protection to trafficking victims, in particular in search and rescue operations. I'm wondering if we can try and identify from your reports where the identification problems were for many of them.
So thank you very much for that question. I think that's really useful because it highlights the identification goes all the way down in relation to the obligations placed on states, but who in fact gives effect to that. So it can be a border guard, it can be somebody, a coast guard, it can be a social worker, agents of the state acting in different situations, but certainly in the context of coast guard operations, it's a positive obligation on the state and the agent of the state to identify that this may be a person who is a victim of trafficking, and then to refer them to a formal identification process, including protection and assistance. But during the time when that formal identification process is taking place, a person shouldn't be returned. And that is triggered, the case law says, anytime there is a credible suspicion. So if a person has been physically brutalized, perhaps subject to sexual violence, doesn't have their documentation. There are all various indicators that are used by the International Labour Organization, IOM, International Organization for Migration, to try to detect possible victims. But the case law language is wherever there's a credible suspicion. Now, of course, if several hundred people are disembarking in one day in Sicily in a hotspot, when we visited the hotspots in Sicily, you had a handful of officials. There wasn't even an interview room. So a tiny medical center, tiny, but no private interview room, for example. So it can, of course, be overwhelming and difficult to respond, but that's where the obligations lie, to try to properly resource that, to ensure that there's information given, that there are interpreters, that medical and healthcare professionals they're absolutely key, that they are trained and they're aware and know how to detect. So, for example, when we visited the hotspots in Sicily, the leaflets that were being given out by IOM and UNHCR officials in different languages showing indicators of trafficking, also they employ cultural mediators to work with different groups to try to build up a situation of trust, to get referrals. But there were no photographs or no references to men or boys. All of the photographs and images were of women and girls. So coming from Libya, there are many men and boys who may also have been victims of trafficking for labor exploitation, for sexual exploitation. We now know that, but that was just missing there. And I had put up there, that was the final slide I meant to come back to, but Shamima Begum, for example, the UK citizen who had her citizenship stripped recently, there's a whole question now of recruitment into armed conflict, potentially for the purpose of sexual exploitation, possibly forced marriage, forced recruitment for engagement in armed conflict. But the problems of identification can also be where there is a reluctance to recognize a person as a victim. So there have been a number of opinion pieces and blogs written. She was 15 when she traveled, so a child. She may have been groomed. This may be a situation of trafficking. Why isn't the state discharging its obligations to investigate, to check? If she is a victim of trafficking, if there's a credible suspicion, if she's 15 when she left, then all of the indicators are there. But if the primary lens through which this has been looked at is the criminal law, criminalization, the criminal justice response, then that's a barrier to identification. So the cases that are pending now at the European Court of Human Rights in relation to the Vietnamese boys, they were brought in to work in cannabis cultivation. We had a situation in Ireland. A Vietnamese adult woman was found locked inside a cannabis grow house, despite the fact that she was locked into the grow house and couldn't get out. She was not identified as a victim. She was prosecuted. So the criminalization lens, the criminal justice response, can also be a barrier to identification. I think we can see that playing out now also in relation to the situation of Shamima Begum, but potentially others in that situation also. The other images of Nadia Murad, just to contrast there, she has been given various UN awards, is recognized as a victim of trafficking for the purpose of sexual exploitation. Any other questions?
Thank you for your good presentation. My question is in regards to the idea that I seem to see that migration is mostly a matter of state actors. However, I realize that because there's employment involved and recruitment, certainly we have to think about non-state actors. Mm-hmm. So with the global compact, does it have any strategies to reach out to those non-state actors? I don't know if you understand.
Yeah. In relation to the risks of exploitation?
Exploitation, yeah. Yes, but also in terms of
facilitating
assessment. Mm-hmm. In terms of assessment, ideally, I'm thinking about the situation in a country like Libya, mm-hmm. where you have a state that is not fully functional, mm-hmm. but then the businesses and global corporations, which could be accountable, mm-hmm. one or another, they facilitate trafficking. Mm-hmm. The state is not in a position to even regulate them.
Yeah, no, in relation to, you have a number of initiatives in the context of the labor exploitation context, in looking at supply chain management, for example, and transparency in supply chains. That tends to focus on larger corporations, but it is one strategy to highlight the potential for forced labor in the supply chain. But at a broader level, it is primarily non-state actors that are involved in trafficking networks, and including in particular in the Libyan context, as you said. And there, the state's obligations to prevent and prosecute, investigate, they still apply. But also the Global Compact does talk about trying to facilitate, to some extent, regular migration through work permits, visas, expanding labor inspections, for example, to engage with smaller units in the labor context, in hotel and catering. The role of civil society and trade unions then are critical to reach out to and engage with workers in those different contexts. So that's the gap, if you like, as you highlight. The obligations under international law fall on states, but most of those who are directly affected, either as potentially being involved in exploitation, or the victims, of course, are non-state actors. So there is all of the cases we mentioned there involve non-state actors. So there is an attempt to look at ways to engage non-state actors, but also the state can be held responsible if they don't effectively prevent trafficking, for example, if they don't resource labor inspections, or don't regularly visit agricultural farms or berry picking or fruit farms in southern Italy or southern Spain, or don't look at the criminal activities of militia groups. The interesting thing in Libya, of course, for the International Criminal Court is that to bring it before the International Criminal Court, they have to show that it's linked to the armed conflict situation. So what they're trying to do is track the money flows. And that includes their interviewing victims of trafficking who are in Europe, who've come through Libya, and trying to see where are the financial flows, where are they going? Are they being used to fuel different sides of the conflict? And if they are, the International Criminal Court may be able to engage. But it's a hurdle, it's a block. Yeah.
I had a question. How much is the migration crisis not engaged?
Mm-hmm. I think more recently it's not, in that it's become very much about irregular migration, and having to control and manage migration. And there's a concern around the kind of anti-immigrant populist politics. But there's been a shift away from looking at the risks of exploitation. And I think the Italian context is particularly worrying in that there were a number of very good initiatives and very active NGOs on the ground. UNHCR had a whole pilot project that was being rolled out to identify victims of trafficking in reception centres. But now with the change in government, with the enactment of the Salvini decree, the security decree, the shutting down of reception centres, that focus on exploitation and a human rights response has really gone away, I think, in those limited pockets. So it's more difficult. It's been seen as a situation of irregular migration. Victims of trafficking are seen as trying to jump the immigration queue to make a claim that isn't believed. So the assessment of credibility is always a problem. The person is simply not believed, and in particular adult men and adolescent boys. So 15 to 17-year-old boys, adult men who claim to be victims of trafficking, they are simply not believed. And that's what happened to the Bangladeshi farm workers, for example, in Greece. The Vietnamese boys in the UK, the children in the Calais camps. They're seen primarily as irregular migrants, and the exploitation situation is not recognized.
How do you see the role of the European Court of Human Rights, and at what level do you see your work? And also, I think it might be relevant for the audience here in terms of regional human rights system. How do you think that your work is biased with the court's evolutive interpretation? Or do you see your role sometimes more progressive? Or do you need to have some additional work to push to the court to get more progressive in its approach?
Yeah, no, that's a very interesting question. If we look at the Chowdhury judgment from 2017, there the court cited very extensively the Anti-Trafficking Convention and the reports of the group of experts. And that was really important because they said that Article 4 of the European Convention on Human Rights has to be interpreted in light of the Anti-Trafficking Convention as interpreted by the treaty monitoring body, GRETA, the group of experts. And that is really important in terms of the credibility of the monitoring process. So when the group of experts is going to a country like Hungary, where there is going to be significant pushback, or Italy, that you can point to the court's judgments as saying, this is how the concept of human trafficking must be interpreted in light of the reports from the group of experts. And the Chowdhury judgment in particular was significant around the scope of positive obligations, they said, on the state to identify that they should have had labour inspectors going to the farms. They should have been looking at what was happening in terms of the initial responses to the complaints. Another situation, a Nigerian woman, Ellie versus Greece, she had waited 9 months before being identified while seeking asylum in Greece. And they said that was too long. You have positive obligations to take action. So for the moment, there's a lot there that's of interest, but there were a lot of earlier cases that didn't even get to the court that were deemed inadmissible. And the concern is looking at those that the complaints being brought were simply not believed. So credibility remains, even European Court of Human Rights is not supposed to be a fact finder, but that seeps in. But we have seen a number of important cases, and the judge who handed down the lead for the Chowdhury judgment, Judge Sicilianos, has just been elected today as President of the European Court of Human Rights. So he is very good on questions around human trafficking and really engaging. We had a number of exchanges of views directly with them, and the group of experts is now an intervening party in 2 cases that are coming before the court. One that was against Croatia on internal trafficking, and the case relating to the Vietnamese boys in the UK. So there's potential there, but this was from one particular chamber of the court. You know, a different composition, you just don't know. It's problematic. But the Khan versus France judgment on the Calais children is quite a strong judgment, although there's been some criticism as to why it didn't reach the level of inhuman treatment, why only degrading treatment. But nonetheless, it's a breach of Article 3, which is significant. But yes, it's the European Court of Human Rights. The Inter-American Court has typically been much more expansive on the protection of migrant rights. So, but we get a sense more recently from the court of impatience at what's happening at state level in relation to some of the migrant situations. But the search and rescue situations, the Sea-Watch cases, they're all pending before the court. So we'll have to see. Yeah. And the Global Legal Action Network, GLAN, is an NGO. It's based in Galway at the Irish Centre for Human Rights. So I would say check out their website. They're doing great strategic litigation work. Yeah. That might be a good point in which to finish.
Right, we do need just a couple of things. If you'd like to get a copy of PowerPoint, you can write to cloudcenter@nd.edu. I'll send it to you. If you could try to do that today or tonight, be great. I'll just send them all out to all of you at once. I think we have enough announcements.
Hi, I'm Director Siobhán Institute. First, a quick announcement. A week from today, we're going to have Michelle Mendes in from Oxford. She's going to be talking on making Oscar Wilde. It's going to be right here next Monday, 3:30 in this room. It's an extraordinary book by a wonderful scholar. So if you have any interest, please do come along. Secondly, I would like to thank our partners from Cloud Center. This was great, and it was wonderful to, Diane, thank you so much for introducing me. I hope that we can do more together. So
keep your eyes peeled for mountain events that will be done in conjunction with our key partners at the cluster. And finally, I want to thank Siobhán. Siobhán, it's particularly gratifying for us because we do so much with Galway. So we're going to be doing more and more of that. Please join me in thanking them.
Thank you, and I would particularly like to thank Mary Henderson for all her help in organising the event, and my good friends and colleagues, Professor Dermot O'Gallone and Mary O'Callaghan, sitting there at the back. So thank you.
Yes, yes. Exactly. I would love that. And I just yes, yes. So that they will last.
Yes, I've been to
What's your turn on ratio? 30. Oh yeah, you have to turn on my ear like on it. Shit.
You have some fans.
You take care of those.
Yeah, in case he travels like that. Shoot you an email.
Yes, I will.
Your time with spirit.
It is already online.